morning. Welcome back to the e-Discovery Zone, broadcasting live from the TechLaw Solutions booth at Legal Tech New York. It's day 2 of Legal Tech, and we're very happy to have with us this morning attorney Ralph Losey from Jackson Lewis. You may know Ralph from his blog, the e-Discovery Team, but we really want to ask Ralph about a new venture you've got going to finally educate attorneys on this whole e-Discovery thing.
Yes, indeed, and we're going to do a close-up.
You, and I was trying to explain it to Browning this morning, had a fascinating statistic you gave last night when you were making your predictions along with Craig Ball at the Theos dinner. And you had one about the percentage of case budget since you had been practicing that was devoted to discovery disputes.
Metrics and technology, I kind of lump them together. And metrics basically is just trying to measure things and get a handle on it. And then particularly now that I'm at Jackson Lewis, I've been worrying a lot about proportionality. It's not, how do you keep things in control cost-wise? You don't want to spend $100,000 just doing a document request in a case that's on its best day is worth $200,000.
Right.
That doesn't make any sense. And all it does is encourage abuse of discovery, just to put a request out there, not because you don't want the information, but because you're going to make them settle. So
right.
I don't want that. I want to try and protect people from abusing discovery. So I've been thinking a lot about metrics. Long story short, cases today, it's not uncommon for e-discovery alone to be half of the total litigation budget.
Right.
Sometimes even more. I mean, there's some cases that are public we can talk about. In my neck of the woods in Florida, over Daytona, NASCAR, they got hit by what turned out to be a frivolous antitrust case, a case where they were sued in Kentucky federal court, and they were ordered to turn over documents. It's of record that they spent $1 million in less than 2 months to do the document review, get stuff off backup tape. And I know also that counsels gone public, cost them $3 million altogether. The case was summary judgment in their favor. And you can chime in.
But Ralph, I read your most recent blog, and by the way, if you don't go to Ralph Losey's blog, you're really missing a bet. And it really talked about getting away from sort of the traditional formulation of what is discoverable and focus down on relevance. In other words, you had sort of two circles. You had an outer circle of the calculated to lead to, and that's where a lot of the mischief lies, and a lot of the cost. I heard another metric here recently that said something like 70% of what we deal with is unnecessary and doesn't lead to this stuff.
I think it's a higher number.
Really?
I call it the 98% rule, and 98% of the information that an enterprise has is probably not relevant to a particular lawsuit. There may be some exceptions.
Sure.
And so you've got 2%, but that 2% can be still millions of emails, and you may have to review that. Out of that, the 2% that's relevant, we're finding that really 98% of that is relevant, but who cares?
Right.
And so really what we're really looking for is the 2% of the 2%, the highly relevant. Now I've called for an amendment to the rules of evidence and procedure to at least get rid of this reasonably calculated to lead to the discovery of admissible evidence, and let's just at least have admissible evidence when you're in an e-discovery situation. The spigot is so overwhelming, but let's narrow it down. It's easy to do, just adjust the meaning of relevance. It'd have to be in the evidence code too. And so that's one way of dealing with it, because at a trial, forget the 2%, that 2% of 2% can be still thousands of documents. We all know at a trial, the jury can only remember 3 or 4, right? And you got a bench trial, maybe it's 30 or 40, maybe, and that's, a judge that has an easy docket can study 30 or 40. So let's focus on the key, the highly relevant, the hot documents. That's really what we should care about. So that's one of the things metrics, I think, helps you do. But what I was getting at, to get back to your question, my prediction and stuff, is that I'm trying to scale back the amount of money that we're spending on e-discovery so there'll be more money left for trial lawyers. 3 of us have all actually done trials, back in the days when they had trials. I want the next generation to have trials too. Instead of blowing all the budget on looking at email, let's scale down what they have to spend so there's money left to do trials. So what I was talking about, when I first started practice in the early 80s, before it was really big paper documents, I would say it would maybe just 2 or 3% of a budget was spent doing a document production, making production, reviewing it. And then when the numbers of paper, I blame it on Xerox, all the copies and the fax machine came, I'd say by the late 80s, it started going up to maybe 5 or 6% of a budget was spent doing document reviews, and we thought that was a lot. And now, like I started, it's more like 50 or 60%. So my goal is scale it back down. I want to get us back down to 5 or 6%. Now I know the vendors are going to go, oh my gosh, what's going to happen to our $6 billion industry? But what will happen is, instead of avoiding e-discovery, like we all know another 98% of our profession does, because they don't want to blow the budget on it. They want to save the money to take depositions and to go to trial and negotiate, mediation, etc. I think what will happen is the industry as a whole will keep growing, but it'll be in volume. And there'll still be the few big cases. There's always going to be the big cases, the second request, the big mergers, where there'll still be the millions and millions of dollars spent. But otherwise, I think we're going to get down to the point where we're spending less. We may still be making large productions, but we'll be smarter about it. We'll use predictive coding, suggestive coding. That's what I'm talking about today, predictive coding, things like that. So it'll be more efficient. But that's my goal, is to start reining in the amount, and the theme is proportionality.
Right.
You know, be proportional in what we're doing. As, I mean, the whole point of this is evidence gathering, right?
Yes.
To resolve a dispute.
Well, I think one of the things that I think we need to do a better job of as a profession, and maybe we're doing it, is bringing in the concept of risk analysis. In other words, there was never perfect paper discovery. There is no perfect e-discovery. You know, at some point, notwithstanding some of the pronouncement in some of the cases, I think we as trial counsel need to go to our clients and say, we're not going to do everything. Now, you've got to temper that with being transparent with the other side, and saying, here is what it is that we are going to do. And oh, by the way, we think going beyond that is not reasonable. And take that risk. I think if you did it in a stealth manner, you might have a problem. But being, I think Ron Best has got a great comment. He calls it aggressively transparent, and says that's where we're going to go in this thing. So, and you know, trying to figure out what is really important in this case.
I think that's part of the solution. I mean, the truth is, there are people that know how to do e-discovery in an efficient manner. The problem is, there's not that many. And that's where I come back to the training thing. That's why, to me, the fundamental thing that I think I can do to kind of advance the profession right now at my final years in the profession, I've been doing a long time. You guys may have, I know Browning's got some years on me, is I want to try and share education, just like you guys are doing with these interviews, to get the word out there, because the informed attorney that understands this stuff will be able to go back to the old days where they don't blow the $1 million budgets and they have money left for a trial. By the way, the Victor Stanley trial is going on right now as we speak.
Oh, is it?
Yes. It is, yeah. So some things will go to trial even if there is millions, and they got a $1 million fee award too, from the judge. So I mean, education to me is the key, and that's what I'm excited about.
Well, tell us about that.
I'm really thrilled you two guys are among my experts.
Yeah.
Because what I've done is I took the law school course that I designed and I taught.
Right.
And you know, I got a lot of feedback from my students. Law students are picky. I made it a serious course, got approved by the faculty. It is a 3-credit course in law school, 50 hours minimum. If you do all the homework, like they suggest in a law school that you spend 3 to 4 hours for each hour of class. If you're doing the maximum and reading all the cases that I give homework, unlike in law school. I give guided reading. Here's what I suggest you read, and here's go research this. I give them questions that they then give answers to. So there's 50 to 150 hours, so it's serious study. That's what it takes to learn this field. It's complicated, but this is an intro level. We're going to have more advanced levels. It's designed for paralegals, techs, computer science, technology people, lawyers, in-laws that are out, lawyers that are just getting started, or law students. So it's designed to all levels. And the beauty of it is it's online, so they can do it at their own time, their own place, and their own pace.
Right.
And it's 150 hours, a big commitment, but not if you can do it when you want to. And this is the land of opportunity. And I deal with a lot of young people, and I get them to thank me all the time, say, so glad that you turned me on to eDiscovery. Nobody else in my firm knows how to do this. That when they hear I've had a class or had training on it, that everything gets referred over to me. So it's a huge opportunity for those who are willing to make the commitment of any age. You want to retool, you're our age, you want to do something different, like I am, I'm doing something different, you should, change is good. So this will give you an ability to learn about it online, giving away the first quarter, and then if you like it, all you do is give me your name and email, and I give you the secret password and you're in. And then if you like it, then $500, you can take the whole course,
Great.
Which is equivalent to a law school course.
I would hope that your target audience not only includes lawyers, but we've got this wonderful growth of lit support folks.
Absolutely.
And they.
So it's open to all of
anybody,
IT,
anywhere. I
support.
mean, there's no application if you're interested enough to do it.
Perfect.
You're welcome to do it. In fact, I would say so far, it's half and half, lawyers and non-lawyers of all different stripes. Surprising thing is, it's people from all over the world.
Good.
My first student was a PhD in computer science in Germany. Said he just wanted to learn it.
Excellent.
People in Australia. So it's a global thing now, eDiscovery.
Yeah.
As we heard today in the keynote speech here at Legal Tech. So.
Well, listen, before we wrap up, any other predictions for the year? I mean, we've got the cutting the costs and education, which is near and dear to our heart, but anything else you'd like to leave our audience with that you think is going to happen this year?
Well, I could do some of the ones I shared last night.
Yeah.
I predict that Judge Grimm will write another excellent opinion in excess of 100 pages, keeping me up late one night reading it all so that I can report it to you, my readers. Thank you, Judge. I mean, he does such a meticulous job. That'll happen. I think maybe Judge Scheinlin will have a new opinion coming out this year. I think maybe we'll see something beyond a pension committee. I don't know that, but I just feel like maybe she wants to write another opinion on it to clarify some of the things. I think she's been widely misunderstood, and I'm always writing kind of defenses. I don't think she clearly said perfection is not possible. We all get that. We're in the real world. You can't do anything. And the truth is, the law has never demanded perfection, or we'd all be in jail. I mean, all that requires is reasonable efforts, right? But it's the bad faith that is what caused Judge Grimm to impose that jail sentence kind of thing. Right. Clear evidence of bad faith. So if you have good faith and you make a reasonable effort, you're going to be okay. Just be prepared to explain that to the judge. Take good notes of what you did. Be fair, be transparent, don't try and play games, don't try and cheat the other side. If you do that, you're going to be all right. You'll be protected. And that's nothing new, but I think more and more people are going to get this and stop misconstruing pension committee to be too high a standard.
Okay.
So I'm hoping that we'll see more proportionality when people look at the numbers. What is this going to cost us? And we're going to come back to what's a reasonable effort here. And preserving every last bit and byte, every backup tape, every employee. Come on, that's not reasonable.
We don't need it.
We don't need it. Costs too much.
Great. All right. Well, thank you very much, Ralph. We really appreciate you stopping by. Once again, Attorney Ralph Losey. And you have to go to his blog, the eDiscovery team, E-Discovery team.
Right.
And underneath that is the URL for the training, eDiscoveryTeamTraining.com.
Right.
So please visit both of those sites.
See you around.
That's all we have for this.